Good afternoon. My name is Kim Stanger. I'm the head of Holland & Hart's Health Law Group. We'd like to welcome you to the first of our webinar series for 2015. Today we're going to be talking about Stark. I hope you all had great holidays. There's nothing better than to start off the new year discussing the federal Stark law. Stark, an important issue. Last year had some of the biggest Stark fines come down that have come down under the statute, including the Florida case involving Halifax Hospital that resulted in a whopping $85 million because the physician compensation structures were allegedly not structured to comply with Stark, as well as perhaps paying some physicians, at least what the government thought, more than fair market value. The bottom line there is it's important to remember the Stark law when you're dealing with physicians in order to avoid those types of repayments. So this is what we're going to cover today. We're going to cover the general issues about the Stark law, including what it prohibits, the penalties if you fail to comply with the Stark law, and the safe harbors, which will keep you safe. We'll apply those Stark laws and the safe harbors to common situations. We'll discuss how you respond to potential Stark problems if you happen to notice one out there, including some comments about the self-referral disclosure protocol. We'll finish up by talking about some action items. If you have any questions, feel free to use the chat feature. You can send those to me or send me a quick email and I'll respond offline. As far as preliminaries, by way of written materials, you should have received a copy of the PowerPoint slides, a copy of the Stark regulations, and an OIG publication concerning Stark issues. This program will be recorded and available for download at our website in case you would like to use it for your own internal training or you haven't got anything better to do and want to share it with your significant other tonight. If you have questions, please submit them, again, using the chat line or you can email me. Also, this program provides an overview of the relevant regulations. Stark is pretty complex. We're not going to get into all the nuances. So when it comes time to actually applying this stuff, it's important that you actually read the regulations or consult with a qualified expert when applying the law to the facts. And remember that this is only one of the laws that may apply. Anytime you've got a Stark issue, there's a good chance you've also got an anti-kickback statute issue. There could also be state laws out there that apply, whether they're state versions of anti-kickback statutes, or some states have their own self-referral prohibitions that are referred to as mini Stark laws that may also apply. So make sure you don't forget about those state laws. With that said, let's talk about Stark. By way of background, Stark came about because the government noticed back in the 1980s that there was this increase in the amount the Medicare was being charged for different types of ancillary services like MRIs and the like. So the government did a study to find out why in the world are we having these costs go up for clinical services, those types of things. And the government concluded that, hey, surprisingly enough, if the physician has an ownership interest in one of these other entities, that physician is more likely to make referrals to that other entity. The government was concerned that allowing the physicians to refer to entities in which the physician had a financial relationship would improperly influence medical judgment, promote overutilization, and ultimately increase the cost to Medicare and Medicaid. The result was the Ethics in Patient Referrals Act, which was propounded by Representative Pete Stark from California, hence the Stark Law. The statute is found at 42 U.S.C. 1395 NN. The regulations, which are really what we deal with on the most frequent basis, are found at 42 CFR 411.350 et sec. And you now have your very own copy of those. What does Stark say? Well, Stark says that if a physician or a member of the physician's family, so it not only applies to the physician but their family members, if that physician or a member of the physician's family has a financial relationship with an entity, that physician cannot make referrals to that entity for certain designated health services that are payable to Medicare. And if they do, that entity cannot submit a bill for payment for DHS referred or rendered pursuant to that prohibited referral, unless they've structured the deal to fit within a regulatory safe harbor. Now, that time period that if you fall out of Stark, that time period in which you cannot, that physician can't make referrals to you and you can't bill for those services is called the period of disallowance. That begins when the financial relationship fails to satisfy one of the safe harbors, but it continues until that relationship is brought into compliance, and if you had a compensation arrangement that fell out of compliance because you were either overpaid or underpaid, it continues, that period of noncompliance continues until the amount of that overpayment is repaid. So prospective compliance alone does not end the period of noncompliance. Also, just because you correct the situation going forward does not mean that you can avoid a repayment obligation. What are the penalties for a Stark violation? Well, at the very least, there's no payment for services that are rendered per an improper referral, so you can't get paid. And if you have been paid improperly, you have an affirmative obligation to repay money received from improper referrals within 60 days. Stark says you've got to repay it within 60 days or else you get hit up with a civil monetary penalty of up to $15,000 for each claim improperly submitted. Physicians can also get hit up with a penalty of $100,000 for each scheme that they've developed to try to circumvent Stark. So the penalties can add up awfully quickly. In addition, you could be subject to penalties under additional statutes because a Stark violation is likely a False Claims Act violation because when you submit that claim to the government, you are certifying that you have complied with the regulations. And if you fail to comply with Stark, you have now submitted a false claim. A False Claims Act penalty can result in additional penalties of $5,500 to $11,000 per improper claim. You can also get hit up with treble damages. You can be a party of a key tam litigation. For example, in the Halifax case, that whole deal came about because the compliance officer realized that they were not complying, and therefore she brought what's called a key tam lawsuit, where she's essentially a bounty hunter on behalf of the government, where she sues on behalf of the government and is able to recover a portion of any penalty. And under the False Claims Act, you could be excluded from Medicare and Medicaid. Now, Stark violations may also violate the anti-kickback statute. Unlike Stark, the anti-kickback statute is a felony, so you can go to prison. You can also be hit up with fines of up to $25,000 per violation, and it's in the wake of the Affordable Care Act. An anti-kickback statute violation is also an automatic violation of False Claims Act. Again, you can be excluded from Medicare and Medicaid. The bottom line is you don't want to go anywhere near a Stark violation. You're better off structuring your deals up front to make sure that you comply with the Stark law. Let's talk more about the Stark law. Stark law applies if there's a financial relationship with a physician or family member and that physician is making referrals for certain designated health services. Stark does not prohibit the financial relationship with a physician. Stark just says, hey, if you got that financial relationship with that physician can't be referring these designated health services to you, and you can't bill for those unless you structure the deal to fit within a regulatory safe harbor. Now, unlike the anti-kickback statute, Stark only applies to referrals for certain designated health services that are payable in whole or part by Medicare, including these items that are on your screen, the things like inpatient and outpatient hospital services, outpatient prescription drugs, clinical labs, physical, occupational, or speech therapy, home health services, radiology and certain imaging services, and so forth. Stark has definitions for each of those. In addition, the government has posted on the CMS website a list of most of the CPT codes that are designated health services. So if you want to know whether a particular service is a designated health services, you can begin by going to that government website that has the CPT codes listed, and I'll show you that a little bit later. Now, with limited exceptions, designated health services do not include services that are reimbursed by Medicare as part of a composite rate. So even though you have something that might otherwise be a DHS, if you're paid on the composite rate, that does not trigger Stark. It's not considered a designated health service. For example, that would be skilled nursing facility Part A payments or services in an ASC that are paid on a composite rate per the regulation that's on your screen. This is the exception that allows physicians to have ownership interest in ASCs without violating Stark. Now, unlike the anti-kickback statute, Stark only applies to financial relationships with physicians or their family members. Physicians, for purposes of Stark, are MDs, DOs, oral surgeons, dentists, podiatrists, optometrists, chiropractors, and so forth. It's not nurse practitioners, it's not PAs, it's not other types of healthcare providers. In addition, Stark also applies to financial relationships with the physician's family members. So, for example, if you're a hospital and you employ the spouse of a physician, then you've got to make sure that that spouse's contract complies with Stark. Family members are the spouse, parent or child, sibling, step-parent, stepchild, or step-sibling, grandparent, grandchild, or in-laws. Now, Stark, again, doesn't prohibit a financial relationship. It just says if you've got a financial relationship with a physician or family member, that physician can't make referrals, and you can't bill the government for referrals for certain designated health services. Referrals is very broad. It's orders, requests, plan of care, certification by a physician. It applies to referrals or orders to other providers or other facilities. It also applies to physicians' referrals within their own physician group. So if the physician's making a referral within their own group to another group member, or maybe to a tech to provide an ancillary service that's a designated health service, or a physical therapist or something like that, then Stark could also apply there. Now, Stark does not apply to services that the physician personally performs. If the physician is personally performing it, it is not deemed to be a referral. So you can always have situations where the physician performs the services himself. The problem is if the physician is ordering or referring services that are going to be performed by somebody else. And in the case of technical fees, for example, you may have a situation where a physician comes in, they perform the surgery themselves, but they've also, in conjunction with that surgery, they've ordered a lot of technical or ancillary or facility fees. In that situation, Stark would not apply to the services that the physician personally performs, but it would apply to the services, the ancillary service facility fees, or those things that are associated with the physician's services. Referral does not include many of the services that are performed by radiologists or pathologists because they generally don't make referrals. They just get referrals. They don't make referrals. That's not a complete, there are some circumstances where Stark might apply, for example, in the case of interventional radiology and the like, but in general, Stark usually doesn't apply to most of what radiologists and pathologists do. Now, Stark applies if there is a financial relationship with the referring physician. That can be a direct relationship or it could be an indirect relationship. For example, you contract with an entity that's owned by a physician. That could be an indirect financial relationship. Financial relationship, again, is very broad. It could be an ownership or investment interest. For example, that physician may have own stocks or bonds, partnership or membership shares, secured loans, securities, etc. It could also be a compensation arrangement, which is basically any remuneration, anything of value between the physician and the provider of designated health services. It could be an employment agreement, it could be an independent contractor agreement, it could be a lease, payments, gifts, use of free or discounted items or services like free space or free equipment, and virtually any other exchange of remuneration. Now, unlike the anti-kickback statute, which is an intent-based statute, Stark does not require intent to violate the statute. If you have a violation and you tell the government that, hey, I didn't intend to violate the statute, the government will just laugh at you because Stark is what we call a strict liability statute. There is no good faith or technical compliance. You either comply or you don't comply. Your intent is irrelevant. So to comply with Stark, you must make sure that the transaction must either fall outside the statute, meaning that there's no financial relationship or a referral with a physician, or you've got to make sure that your deal is structured to fit within a regulatory safe harbor. There is a limited exception to that. Stark says that if you have a situation where you've got a financial relationship with a physician, that physician has made a referral to you, you have billed the government, but you didn't know that that referral came from that referring physician, did not know and did not act in reckless disregard, In that situation, you're not responsible for improperly submitting that claim. You wouldn't have to repay in that situation, but it's a relatively limited exception. What's more important is to ensure that you structure your deals with physicians to comply with a Stark safe harbor. Stark has numerous safe harbors. Some of those are applicable to both ownership and investment and compensation arrangements. Some of them are applicable to only ownership or investment arrangements. Some of them are applicable to only compensation arrangements. There is no liability under Stark if you comply with all of the requirements of an applicable safe harbor. 99% doesn't get you there. You got to make sure you comply with all the requirements. And you need only comply with one safe harbor for each financial relationship. For example, it may be that if you're a group and you're an employee and a physician, you could rely on an exception, Stark's employment safe harbor exception, or the personal services exception, or the fair market value exception, or one of the group practices exceptions. You just need to comply with one of those, even if you don't comply with the others. So long as you comply with one, then you'll be okay. You got to make sure that you comply with an exception, though, for each of your financial relationships. Sometimes your relationship with a physician may involve multiple different types of financial relationships. Maybe you have an independent contractor agreement, but you're also leasing space to the physician. In those situations, you got to make sure that each financial relationship is structured to comply with a safe harbor. So what are the exceptions for both ownership and compensation arrangements? Well, there's an exception, there's two exceptions that are very important to group practices. There's the physician services exception that applies to physician services rendered by another physician in the same group practice or under such physician supervision, or the in-office ancillary services that are provided through the group practice. These are the exceptions that allow you to make referrals within your group, so long as you comply with Stark. But in order to fit within those exceptions, you've got to qualify as a group practice under Stark. We'll talk more about that later. There's also separate exceptions for prepaid health plans, blah, 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 several other items, and intra-family rural referrals. Even referrals back and forth between family members could violate Stark. We'll talk about that in a little bit. Well, what are the exceptions for only ownership or investment interests? The most important of these is the rural provider exception. We'll talk about that more later. There's also an exception if a physician has an owner or a family member of the physician has an ownership interest in the whole hospital, not just a division of the hospital, but the whole hospital. Those exceptions were narrowed under the Affordable Care Act and is subject to some additional limitations. There's exceptions for an ownership interest in a publicly traded security and large regulated mutual funds. Usually you're dealing with exceptions for compensation arrangements. What are the exceptions? The Stark safe harbors for compensation arrangements? Well, there's exceptions for employment relationships, personal services contracts, office or space or equipment rental relationships, physician recruitment or retention, remuneration unrelated to designated health services, fair market value, non-monetary compensation up to $300, medical staff incidental benefits, some compliance training, community-wide health information systems, professional courtesies, certain payments by a physician for items or services at fair market value, and several others. Stark has a provision, the statute and the regulations have a provision which contemplate that entities are supposed to report financial relationships with physicians, but we generally have not got the implementing regulations, and so we're not required to do that. That could change at any given time, but there's nothing on the close horizon requiring those reports as of yet. So that is a brief overview of Stark. If you want to know whether or not Stark applies, here's the four-step process, the analysis you need to go through. First, is there a financial relationship between the DHS provider and the physician or the physician's family member? Remember, that could be a direct or indirect relationship. It could be an ownership or investment interest. It could be a compensation arrangement. If there is no financial relationship, you don't have to worry about Stark. On the other hand, if there is a financial relationship, you've got to ask yourself, does that physician make or has she made referrals to the entity for certain designated health services payable under Medicare? If there's no referrals for those designated health services, you don't have to worry about Stark. You may have to worry about the anti-kickback statute or state laws, but you don't have to worry about Stark. Number 3, if there were those improper, or if there are referrals being made, you've got to ask yourself, okay, has the deal been structured? Do we fit within a regulatory safe harbor? If you do fit within a regulatory safe harbor, you're fine, you're all right, but you got to make sure you comply with all the technical requirements of that safe harbor. If you don't fit within the safe harbor, well, the bells and whistles ought to be going off. You ought to be getting a little bit nervous. If you are an entity that bills for the items or services, you could still ask yourself, have you billed for items or services pursuant to an improper referral? And if so, did the entity have knowledge of the physician's identity? That is the general Stark analysis. Let's apply Stark to some common relationships. More specifically, let's talk about some of the relevant safe harbors that would apply. As we talk about these common relationships, ask yourself the following. Do you at your organization have such financial relationships? And if so, do your relationships fit within the requirements of the applicable safe harbors? Let's walk through some of those. First, employment arrangements. Remember, Stark applies to arrangements with physicians or the physician family members. In order to fit within the Stark safe harbor for employment agreements, that employment has to be for identifiable services. The compensation you pay has to be consistent with fair market value, so you're not overpaying them. If you're overpaying them, the government thinks, well, you're really paying for the referrals, which is not appropriate. So the compensation has to be consistent with fair market value. It cannot be determined based on the volume or value of referrals made by that physician. And the compensation has to be commercially reasonable even if no referrals were being made. Now, the safe harbor says you may pay that physician a productivity bonus for personally performed services. So the services that physician personally performs, you can pay them a productivity bonus based on that. But you generally cannot pay them based on referrals for ancillary or incident to services. That's the alleged problem with the Halifax Agreement, where the compensation structure for some of these physicians, they were paid an incentive bonus based on tests or drugs that those physicians ordered. And in that situation, the government said, no, can't do that. That doesn't fit within the employment arrangement. Now, note that the government goes pretty easy. It's fairly easy to comply with the employment safe harbor. Unlike other safe harbors, you don't even have to have a written agreement if you don't want to. In addition, the compensation structure does not have to be set in advance. So you could pay, change the compensation structure for employees at any time or pay them a bonus later or whatever you want to do, so long as it's an employment relationship. In contrast, if you're talking about independent contractors, not employees, the requirements are a little bit more stringent. You've got to have a written current contract that's signed by the parties. Be really careful about situations where you're paying somebody to provide services for you, but you did not have a written contract. If you're doing that, if this person is an independent contractor, you likely have Stark issues. In addition, beware of situations where you've got independent contractor agreements and that contract lapses and nobody realized it. So maybe the contract was just for a year, that year comes and goes, the parties continue to perform pursuant to that contract, but the contract lapsed. It expired. In that situation, then that may result in a Stark violation. Your contract has to specify the services that are being provided. You can't have any revisions during the first year, especially compensation. So if you're going to enter into an employment agreement, you can have that for any period of time. It can be for 6 months, 3 months, whatever. On the other hand, if you're entering into an independent contractor agreement to fit within the Stark safe harbors, you generally have to make sure that the contract is for at least 1 year. Now, you can terminate it earlier. You can terminate it within that 1 year period, but you can't enter into a new agreement or change those compensation terms during that 1 year period. The theory there is the government didn't want you going in to establish or set up a whole series of contracts where you're changing the compensation based on referral patterns. So you got to make sure that that contract stays in place for at least a year. Under the contract, the services have to be reasonable and necessary for legitimate business purposes. So you're not just doing this sham contract for services you don't really need just as a way to funnel money to a referral source. The compensation has to be consistent with fair market value. It has to be set in advance. So unlike an employment contract, if you've got a contract with an independent contractor, you can't decide willy-nilly to give them some kind of a bonus at the back end of that, because in that situation, that would not be set in advance. The compensation has to be set in advance. Now note that it's only the compensation formula that has to be set in advance. In contrast, the anti-kickback statute says that the aggregate compensation has to be set in advance, but under STARK, you just need to make sure that the compensation formula is set in advance and is objectively verifiable. And your compensation structure cannot take into account the volume or value of referrals or other business generated between the parties. Under the employment safe harbor, you could just have to make sure that that it doesn't vary with the volume or value of referrals for designated health services. Under the fair market value or professional services safe harbors, you've got to make sure that the compensation does not vary with the volume or value of referrals for designated health services or other services, other business generated between the parties, even non-Medicare or Medicaid services. And finally, just like the employment safe harbor, you may pay an independent contractor based on their personally performed services, for example, based on their work RVUs or something like that, but you can't pay them based on ancillary or incident to services. What about leases for space or equipment? You've got somebody that wants to come in, a physician wants to come in and use some of your space or equipment. Generally, you've got to charge them fair market value because that is remuneration. To fit within the STARK safe harbor, for leases of space or equipment, you've got to have a written current lease signed by the parties. Again, be careful of situations where you allow them to use your space without a written lease. Or if you've got a situation where the lease expires. Nobody realized it, but the lease expired. Now, both under the leases for space or equipment and the personal services safe harbor, they will allow up to a 6-month holdover, but it's better yet to avoid that situation. Make sure that you've got an auto renewal in your leases and your independent contractor agreements so that they automatically renew and you don't have the situation where they expire without intent. You can have a termination provision, so you have a termination without cost, so it doesn't really have you create a problem for you to have an auto renewal, and it just protects you in the case of the STARK for a potential STARK violation. Your lease for space or equipment has to specify the space or equipment that is being leased. So be careful about situations where maybe that morphs over time. Maybe that physician starts using more than is really covered by the lease. If that's the case, then that could create STARK problems. The term of the agreement has to be at least 1 year. Again, you can terminate early, but you can't change those compensation terms within the first year period. The lease has to be reasonable and necessary for legitimate business purposes, not just a way to funnel more money to a referral source. It has to be commercially reasonable, even if there were no referrals between the parties. The lessee has to have exclusive use during the term except common areas. This is a common problem that I see. Sometimes you have these shared space or shared leasing arrangements where maybe you allow another referring physician to come in and, yeah, go ahead, use that space, just charge us X dollars, and, you know, we'll just share that. Can't do that and fit within the STARK lease and safe harbors exceptions. Whenever that leasee is using the space or equipment, they've got to have exclusive use of that. It can't be a shared space or shared lease situation. The rent has to reflect fair market value, has to be set in advance and not based on referrals or other business generated between the parties. And in the wake of fairly recent STARK amendments, you generally cannot use a rent formula that's based on a percentage of revenue received, billed, or generated. So you can't charge them, you know, we'll charge you 25% of all of your billings. In addition, you can't charge them a per unit of service or a per click fee if those services are affected by the referrals for the lessor. So to the extent the lessor is going to be making referrals to the lessee, you can't have the rent based on the per unit of service. The theory there is they don't want a situation where the lessor has incentive to make referrals because the more referrals they make, the more rent they get. The government has interpreted that per unit of service issue to also apply to on-demand leases. On-demand leases are really just nothing more than per unit of service leases, and therefore you can't do that if it varies by, if there's going to be referrals by the lessor. And the government warns about short-term leases, which may effectively be on-demand leases. There's another safe harbor that applies to isolated transactions, such as the one-time sale of practice. Generally, that isolated financial transaction, the remuneration paid under it has to be consistent with fair market value, cannot take into account the volume or value of referrals or other business generated by the parties. So when you're doing the fair market value analysis of a physician practice you want to acquire, you need to make sure that you're not taking into account the ongoing revenue streams. Remember, that was part of the Drakeford v. Plumey case, which resulted in large, over $100 million in potential Stark repayments a couple of years ago. The agreement has to be commercially reasonable, even if the physician made no referrals, and you can't engage in an additional transaction within the following 6 months except reasonable post-closing adjustments and a transaction that otherwise meets within a Stark safe harbor. There's exceptions that applies to recruitment situations. Generally, if you want to recruit a physician into your area, you want to structure, and you want to pay more than fair market value, and you're not going to hire them as a contractor, you're not going to hire them as an employee, you want to look at the recruitment safe harbor. To satisfy this safe harbor, you need to have a written contract signed by the parties. The physician has to relocate from at least 25 miles away into the hospital service area, so you really are recruiting this person outside the service area into your service area, not just from across town or using the recruitment to funnel additional perks to referral sources. That's what got the San Diego hospital in trouble a few years ago. Your recruitment agreement cannot be conditioned on referrals to the hospital, so you can't say, okay, we'll recruit you and give you these benefits, but you've got to make referrals to us. You can't do that. If you recruit the physician into an existing group, so you're not recruiting the physician just into the area as a solo or recruiting them to become employees of your hospital, if you're going to recruit them so that they're going to join a separate physician group, you generally cannot subsidize that group. Any money that you pay has to flow through directly to that physician, so it's not subsidizing the group. The hospital payments to the group must be based directly. They must be, again, directly passed to the recruited physician. You can only reimburse the group for their recruitment expenses, not to cover overhead, and any income guarantee you're going to offer has to be limited to additional incremental expenses that are attributable to adding the physician. There are other conditions that may apply to the particular circumstances. The bottom line is if you're going to rely on that recruitment safe harbor, you need to pull out the safe harbor and check the requirements. That recruitment safe harbor is generally only available for certain types of entities like hospitals, rural health centers, and the like. All right, let's talk about group compensation. This is an important one. A lot of people don't realize that Stark applies to referrals even within a group. There are, as I mentioned, significant safe harbors that apply to these intra-group referrals, but in order to do that, you've got to qualify as a group practice under Stark. That means that you've really got to be operating as a group, not just a bunch of separate entities that come together and call yourselves as a group so that you can make these incestuous referrals to each other. To be qualified as a group practice, you got to satisfy the requirements in 42 CFR 411.352. Among others, you have to operate as a single group. That means the group members have to perform and bill at least 75% of their services through the group. You have to have a method of distributing income and expenses that is determined in advance and is not based on referrals for designated health services. So you can't pay your group members directly based on their referrals for designated health services. Now, you may pay a per capita sharing of profits. You can allow your physicians to share in the profits, but you can't have any cost centers or profit centers of less than 5 physicians. In addition, you may pay for productivity bonuses based on the services that are personally performed by the physician, or, unlike the employment safe harbor, you can pay, under the group practice exceptions, you can pay for services that are incident to that physician's services, but you can't pay that physician based on their referrals for ancillary services. You could use any other methodology unrelated to referrals for DHS. The bottom line is, if you were in a group and you were paying Eat What You Kill or some other methodology in which you were compensating your group members based on their referrals, you better go back and take a look at it and make sure that you're going to be able to comply with Stark, because that is a potential big problem. Now, If you do satisfy or qualify as a group practice, then you can get the benefit of two very important Stark Safe Harbors, including the Intragroup Referrals for Physician Services. This is the exception that says that physicians within a group may refer for designated health services that is furnished by a physician who is a member of the referring physicians group or under the supervision of a physician within that referring physicians group. But again, you've got to qualify as a group practice. That's the one that most of you are going to rely on if you're making referrals to others within your group. There's also the in-office ancillary services exception. This allows physicians within a group to refer to others within the group to perform ancillary services, like referring to a tech to perform an ultrasound or an x-ray or something like that. If the services are furnished by a member of the group or under the supervision of a group member, that they are furnished in the same building or centralized building where the group regularly provides the services. So you can't necessarily go out and set up this separate PT company and call that as part of the group and send it over there if that's not operated in your same building where the group normally operates or in a centralized building within the meaning of the Stark regulations. And any of those services, those ancillary services, have to be billed by the referring physician or the group or a wholly owned subsidiary of the group. If you are providing MRIs, CPTs, or PETs, in order to satisfy the ancillary services exception, you've also got to give the patient written notice of at least 5 other suppliers within the 25-mile area who may provide such services so that patients know that they don't have to get it from you, they can go someplace else. That's a requirement that came down a couple of years ago. There is a separate exception under Stark that applies to ownership interests in rural providers. For those of you who live in rural areas, this is very important. Stark generally says, hey, if a physician has an ownership interest in an entity, that physician can make referrals for designated health services to that entity. But the government recognizes in a lot of our rural areas, the only people who are going to invest or bring in these needed services are going to be physicians. And if we're going to prevent physicians from making referrals to these entities in which they have an ownership interest, it's really going to chill the ability for these physicians to open up and provide these necessary services. Therefore, the government came up with this rural provider exception. It says that a physician can make referrals to an entity in which they have an ownership interest so long as the DHS is furnished in a rural area, which is defined as outside a metropolitan statistical area, and the entity furnishes at least 75% of the DHS that it furnishes to residents in a rural area. If the entity is a hospital in which the physicians or family members have an ownership or investment interest, they've got to satisfy some additional requirements, some additional notice requirements. There's the whole hospitals exception that allows physicians to have an ownership interest in the whole hospital and make referrals to that entity. That's the one that allows physicians to have an ownership interest in specialty hospitals. The status, however, as part of the Affordable Care Act and other regulations that came out, they limited the physician's ability to have these. They basically grandfathered in existing relationships, but they limited the ability to create new relationships. So if you are going to rely on this, you need to go back and check the regulations and make sure that you're complying with that. Among other things, if you're going to rely on that ownership in a whole hospital, there's now certain notice provisions that you've got to give to your patients, and you've got to provide you have to have the ability to assess, provide initial treatment, and transfer all patients consistent with EMTALA requirements. All right, just a note about under-arrangement transactions. Under-arrangements transactions are situations where a DHS provider, typically a hospital or maybe a SNF, contracts with a physician or a group to provide the service, but the hospital bills for that service. So the physician group is not billing for the service. The way Stark used to operate is that would not trigger Stark, because a referral to an entity was defined in such a way so it only applied to referrals to the entity that billed for the service. So under arrangement situations, it would not apply to if you're making a referral to somebody else who's not billing for the service, like referrals within your own group. The bottom line, a few years ago, the government changed those rules so that now entity is defined to mean not only the entity that bills for the service, but the entity that provides the service. The net effect is that Stark applies to both the group that can referrals to the group that contracts with the hospital, as well as the physician, the referring physician's relationship within their own group. So you got to make sure that that physician's referrals within their own group complies with Stark, as well as the referrals or the group's financial relationship with the hospital. That dramatically limits the ability to rely on under-arrangement situations to get around Stark. In the wake of the new under-arrangement rules, or relatively new rules, the potential Stark exceptions are if there's no referrals. For example, you're contracting with radiology, pathology, or there's otherwise no referrals within the group, or you can structure the deal fit within compensation safe harbors or the rural provider safe harbor. Generally, you're not going to be able to rely on the in-office ancillary services exception, though. And so if you're dealing with an under-arrangement situation, the bottom line is take a close look at it and make sure that you're complying with the Stark rules. There is an exception under Stark that applies to indirect financial relationships. There's a specific Stark safe harbor. There's also the way the definition for indirect financial relationships works. It allows you to get out of Stark in certain circumstances. The bottom line is this: there is no financial relationship if you've got an indirect, you would otherwise have an indirect relationship with the referring physician, but the closest compensation relationship with the physician does not vary with the volume or value of referrals. So, for example, you may have a situation where a hospital contracts with a group. That group employs a particular referring physician. So long as that employment relationship between the contracted, the group and the referring physician does not vary with the volume or value of referrals, then that hospital really has an indirect compensation arrangement with that referring physician. It actually falls outside the definition of an indirect compensation arrangement, so there's no Stark concern in that situation. You have to be a little bit careful about this, though, because in the wake of fairly recent Stark changes, physicians who are owners of a group now are deemed to stand in the shoes of their group. So what used to be indirect compensation arrangements are no longer indirect compensation arrangements, and you would have to make sure that your structure will fit within that compensation arrangement. There's a Stark safe harbor for professional courtesies. These are situations where you may want to offer, referring physicians, if they come here, we'll give them a discount or we'll charge them. Stark says, okay, you can do that, but you got to satisfy the following. The practice has to have a formal medical staff, meaning at least 2 physicians. If you're a solo practitioner, sorry, you can't rely on the professional courtesy exception. You have to have a written professional courtesy policy that's approved in advance. If you don't have a written policy approved by your organization, then you shouldn't be giving out professional courtesies to referring physicians. It has to be offered to all physicians in the service area, regardless of the volume or value of referrals or other business generated between the parties. The healthcare items or services have to be of a type routinely provided by the entity. It cannot be offered to government beneficiaries unless there's a showing of financial need. And otherwise, you got to make sure it's not violating the anti-kickback statute, meaning that one purpose of this deal is not to generate referrals. There's the Stark exception that allows hospitals and certain other entities to offer items or services that are not cash or cash equivalents to physicians, so long as the value of that does not exceed $300 per year as adjusted per CPI. I believe for 2015 we're up to about $392 a year. So this allows hospitals to, for example, give some of these freebies to referring physicians. It cannot be based on the volume or value of referrals or other business generated between the parties, so you don't determine that based solely on referral patterns or based on referral patterns. It cannot be solicited by the physicians or the physician's practice. So for those of you who are physicians, you can't go to your local hospital and say, hey, I understand I get this benefit, I want you to give it to me. If there's a violation, there's a provision that allows the physician to repay the excess amount and restore compliance, but there are certain conditions that have to be satisfied. In addition to this non-monetary compensation, an entity with a formal medical staff may provide one medical staff appreciation event annually, and that doesn't affect this non-monetary compensation. So if your organization provided a holiday party last month, that probably fit within this particular exception. There's a separate exception that allows hospitals to provide certain medical staff incidental benefits to their medical staff members. It has to be items or services, not cash or cash equivalents. It has to be used on the hospital campus. has to be offered to all medical staff members in the same specialty, not based on the volume or value of referrals or other business generated between the parties. Has to be provided while the physician is making rounds or engaged in services benefiting the hospital or patients. Has to be reasonably related to the patient care at the hospital, and has to be of low value, that is less than $25. There's another exception under Stark that allows you to make referrals to family members in rural areas. A lot of people didn't think, well, wait a minute, does Stark even apply to referrals to family members? Yes. Remember, Stark applies to if you've got a financial relationship with the physician or their family members. This exception applies, this safe harbor applies if the patient resides in a rural area and there's no other person is available to furnish the services within 25 miles or 45 minutes. In that situation, they say, yeah, absolutely, go ahead and refer it to your spouse because she's the only one who can do that service. A lot of people think that Stark says you cannot require referrals of your contractor's employees. That is not actually accurate. Stark actually says that you may condition that physician's referrals on, or that physician's compensation on their referrals. You can require them to make referrals to your organization because, you know, that's why you hire this person. But in order to do that, if you're going to condition their compensation on referrals, you got to make sure that your contract has certain terms. That contract has to contain the requirement to make referrals. The compensation that you pay has to be fair market value and not take into account the volume or value of referrals. And the referrals have to relate solely to the physician's services under the contract and have to be necessary to effectuate the intent of the contract. So, for example, if you're hiring a part-time physician, you can require referrals for the services he's performing while he's performing the services for you, but you can't also require him to refer the services that he performs when he's outside his agreement with you on his own time. You can't require him to refer those services to you. In addition, you cannot require referrals if the patient prefers to go to a different provider, or if there's an insurer that determines the provider, or if the physician determines that the referral to the required provider is not in the patient's best medical interests. In those situations, the physician can always get out of making the referral. But in general, you'll want to, for your physician contracts, want to make sure that you include this type of a provision in there so that you can ensure that, hey, if you're hiring this person to provide ER services at your place, that that physician is going to refer patients to your facility for x-rays and related services that are related to what that physician is performing for you. There are additional safe harbors, but they're really boring, so I'm not going to go through those. Things like compliance training, OB malpractice insurance, physician retention, some EHR stuff, and charitable donations by a physician. So to summarize, when you're talking about the Stark analysis, remember, this is the analysis. Maybe we've gone through a bunch of this stuff. You're wondering, uh-oh, do we have a Stark problem here? Here's the analysis again. Ask yourself, is there a financial relationship between the DHS provider and the physician or their family member? That could be an ownership or investment interest or a compensation arrangement. Does the physician make or has she made referrals to the entity for DHS payable to Medicare? If so, then is there a safe harbor that applies? If there is, then you're good. If you're not, well, you got to be concerned. If you're not, if there's no safe harbor, have you billed for items or services pursuant to an improper referral? And if so, did the entity have knowledge of the physician's identity? If you did, chances are you're going to have a repayment obligation. That brings us to what you do if you think you have a potential Stark problem. Well, if you think you have a Stark problem, don't ignore it or attempt to sweep it under the rug. It only gets worse because that period of disallowance continues to accrue. The longer you go, the bigger potential penalty you have. And remember, you not only have to worry about Stark now, you also have to be worried about the False Claims Act penalties, which are dramatically higher than the Stark penalties. Under the Affordable Care Act, you now have an affirmative obligation to narc on yourself. You've got an affirmative obligation to report and repay payments if you've received overpayments. If you fail to do that, then you can get hit up with all those False Claims Act penalties in addition to Stark penalties. If you think that you've got a problem, then hold up your submitting your claims to the government until you get the issue resolved. There's a big difference between submitting the claims to the government when you didn't know that there was a problem and submitting the claims to the government when you do know there's a problem. In the latter case, that may be a false claim, could subject you to fraud claims or other sorts of things. To the extent you can, if you think that there's a problem, hold off submitting the claims to the government until you get the issue resolved, or at least you investigate it. If possible, suspend remuneration to the physician until the issue is resolved so that you no longer have that physician relationship. That may be difficult. You should evaluate the situation carefully. Make sure you know all the facts. It's possible. I've had some situations where people call me and say, we think we've got this START problem, but when we get into the facts, they really don't. So make sure that you know the facts. Review START for possible exceptions. There are some pretty obtuse START exceptions, and every now and again, it's possible that one of those rather odd or esoteric START exceptions might apply. Sometimes it's just a good idea, even if you know START, to pull out START and take a look at all the exceptions to see if there's anyone that might apply that you haven't thought of in the past. As necessary, seek help from a qualified expert, whether it's your compliance officer or a healthcare attorney. I'll tell you right now, most attorneys out there have no idea that START even exists. So make sure that if you're going to seek advice, that you seek advice from somebody who really knows about START. START does allow you to go to the government and obtain an advisory opinion if you want. But for START, it's pretty rare that you actually seek a START advisory opinion, but theoretically you could. If you get a favorable START advisory opinion, then of course you can go ahead and act consistent with that advisory opinion. As necessary, if you think you've got a problem, revise the agreement going forward, but that doesn't necessarily correct everything that's occurred in the past. It may be necessary to go back and recover or either overpayments or recover additional money if you've been underpaid to terminate the period of disallowance. Remember, in a compensation relationship, if you've been overpaid or underpaid, you need to square up in order to end that period of disallowance. If you don't, that period of disallowance continues and you don't resolve the START problem. If necessary, you're going to have to repay the government. Under START, again, you've got an affirmative obligation to report and repay within 60 days. If you fail to do the report and repayment within that 60-day period, then you could be subject to additional fines of $15,000 per improper claim. As I mentioned, under the False Claims Act, you've now got an affirmative obligation to report and repay an overpayment within 60 days. If you fail to do so, that's a violation of the False Claims Act, which are additional penalties under both the False Claims Act and the Civil Monetary Penalties Law. For those of you who are unfamiliar with that new report and repayment rule, the government issued a proposed repayment rule that talks about these issues. We haven't got the final one yet. In the meantime, you're supposed to act under that proposed rule, which basically allows you to work with your carrier to do the repayment, your contractor. Now, if you do have that overpayment, you have the option of either paying directly to the contractor or, better yet, enter into the START Self-Referral Disclosure Protocol. This was enacted as part of the Affordable Care Act. This is a voluntary program that is designed specifically and exclusively for START violations. If you're going to submit for this protocol, it's not to get an advisory opinion. If you're entering into this, you assume you're going to pay. You're going to have to pay. That's the assumption. What are the benefits of the SRDP, the Self-Disclosure Protocol? Well, CMS may reduce the penalties if you fully disclose and cooperate, and in my experience, they always do. It may preclude a key TAM lawsuit because you've notified the government now, and that generally cuts off the potential for a key TAM lawsuit. Participation in the Self-Disclosure Protocol suspends your obligations of repaying under the False Claims Act repayment rule. So the general rule is if you discover that you've got a problem, you've got to report and repay within 60 days. But if it's a START issue, you enter into the SRDP, that tolls that period. So you don't have to repay until after you've gone through this whole process, which, by the way, could be a couple of years. It may cut off liability and allows finality for pending START problems. If you've got an issue that you've got a contract in place that's been in place for the past 5 years that violates START, well, that's just going to continue to get worse and worse and worse. But by entering into the START Self-Disclosure Protocol, it allows you to finally resolve those problems and be able to move forward without the threat of that prior problem hanging over your head any longer. There are risks to the SRDP. First of all, there is no guarantee that CMS will reduce the penalties. They're not obligated to. They don't have to. But in my experience, they actually are very reasonable in reducing the penalties so long as you go in good faith and you cooperate. There's a risk that CMS may broaden the investigation. You report item A, CMS gets in there and looks and finds out, oh, no, you've also got problems with B, C, and D, which could dramatically increase your potential exposure. Failure to fully disclose or cooperate during the process may actually result in additional penalties. They may say, well, you know, you lied to us as part of this process, and so we're going to come down extra hard on you. CMS may report to other government agencies. So you get the report to CMS. CMS may say, we think there's a serious problem here. We're going to report you to the OIG or the Department of Justice, and you're going to have to deal with those other entities. Participation in the SRDP is fairly burdensome, but it's not nearly as bad as the OIG's self-disclosure protocol for anti-kickback violations or civil monetary penalties law violations. The reopening period runs from the date of the initial disclosure, so it basically can extend the time period for the reopening period. You'd probably waive your appeal rights concerning any overpayment if you accept the settlement. You will likely waive privileges for attorney-client privilege and the like. It's not necessarily so that you do, but as a practical matter, you're probably going to be waiving your privileges. And there is a risk that the information may become public, although the government's been pretty good about keeping the Stark settlements under the SRDP relatively private. If you want to know more about the self-disclosure protocol, you can go to this website, the government's website, dealing with the SRDP. Let's talk briefly about the process. What happens is, if you think you've got a problem, you go ahead and submit an initial disclosure electronically and also send a hard copy submission to CMS. CMS will verify that they've accepted it into the program. They will usually ask for additional information. The government and the SRDP tells you what information they need. That's the information that you submit. They'll come back and ask for additional information. You provide the additional information. Then ultimately, when you get to the end of the process, the government will come back to you and say, this is the amount that we are willing to settle for. This is not a negotiation. Don't go into this thinking that you're going to be able to negotiate back and forth with the government on what you're going to pay. It's a take it or leave it proposition. And all of these that I've been involved in, the government will schedule a call. They'll say, we've looked at your stuff. This is what we're willing to do. You can either accept it or you can reject it. If you reject it, you're out of the SRDP, and therefore you're subject to all the other potential penalties, and you're on your own. Under the SRDP, the government has said when you're factoring in your Stark violation, the amount of your repayment, the government issued an FAQ. It says for calculating that amount of repayment, you only have to go back 4 years. That's the 4-year look-back period. So even though your Stark violation may have gone on for a lot longer than that, when you're calculating the amount of the repayment, you only have to go back 4 years. That is huge. That places a semi-statute of limitations on at least the repayment amount that you're going to be exposed to. But of course, there may be a lot of money that's owed over that 4-year period. Once you enter into that SRDP, it's important that you jump in and you're committed to being fully frank and candid with the government. The government has said if a disclosing party fails to work in good faith with CMS to resolve the disclosed matter, that lack of cooperation will be considered when CMS addresses the appropriate resolution of the matter. Similarly, the intentional submission of false or otherwise untruthful information, as well as the intentional omission of relevant information, will be referred to the DOJ or other federal agencies and could in and of itself result in criminal or civil sanctions, as well as exclusion from participation in the programs. So don't play fast and loose with the government if you're getting into the self-disclosure protocol. Factors the government considers in determining the amount that they're going to make you repay under the SRDP are the nature and extent of the improper or illegal practice, the timeliness of your self-disclosure, the cooperation you've given in providing additional information related to the disclosure, the litigation risk associated with the matter disclosed, the financial position of the disclosing party. CMS has said while they may consider other factors, CMS is not obligated to reduce any amounts due and owing. When you look at this reported Stark settlements, though, however, under the SRDP, it's very encouraging. In the Starks, I've done several of these, and generally, they're for the ones that I've been involved with, when we calculated the amount potentially owed versus the amount the government asked us to repay, we were really only running about 2 to 4% of the potential exposure. And I've always found the government to be very, or at least CMS to be reasonable in dealing with these types of issues. Now, the situations I've dealt with are generally situations where my clients did not do anything really egregious. It was usually relatively technical violations. The government could come down harder on somebody who is doing something intentionally wrongful or very serious violations. But in whole, when you look at the potential settlements or the reported settlements, most providers, I think, are far and away better if there's a stark violation to go through this self-disclosure protocol. All right, in the final remaining minutes that I've got, let me talk briefly about some action items. Well, what do you need to take away from this to make sure that you're complying with STARK? Well, you need to go back and identify your existing financial relationships with physicians, physician-owned entities, or family members of physicians. That could be contracts, whether they're employment, contracts, independent contractor arrangements, medical directorships, on-call coverage arrangements, management agreements, whatever. It could be leases, subsidies or loans, group compensation arrangements, joint ventures or partnerships, free or discounted items or services like use of space or equipment or personnel or resources, professional courtesies, providing free insurance, gifts or perks, whatever it might be. If you've got a financial relationship, you need to identify that and then look at that to determine whether or not you're going to comply with the STARK rules. For example, make sure for most relationships you have a written contract that is currently signed by the parties and that the parties are complying with the terms of the contract. It's really easy for these things to morph over time. Or maybe that physician just really isn't providing the services for which you contracted. There's no documentation to show that they were providing the services for which you contracted. Make sure that you're paying fair market value. Make sure the compensation is not based on the volume or value of referrals, and that the arrangement is commercially reasonable and serves a legitimate business purpose. You should implement a method to track and monitor your physician relationships for compliance. Maybe you maintain a central repository for your contract. Make sure you're tracking termination dates so that when that contract is about to expire, you know it so that you can make sure that that contract doesn't lapse and suddenly you're out of STARK compliance. You should have a process for obtaining confirmation of compliance before you enter into these arrangements. So you should have a process where any financial relationship involving physicians, whether it's through marketing, whether it's through use of space or leases or contracts for services, that all of that goes through your compliance officer or somebody else who knows about STARK so that they can check off and make sure that you're complying with STARK. Ensure your compliance policies address STARK. In the OIG Supplemental Hospital Compliance Program guidance, they give you the elements of a required or a suggested compliance program. Pull that out and take a look at your compliance programs and make sure that they address STARK issues and you've got processes in place that will help ensure your compliance. Then train your key personnel concerning these STARK issues, certainly your administration, your compliance officers and committees, but also human resources, physician relations and medical staff officers, marketing and public relations, your governing board members, accounts payable, all of these entities, they should know about the STARK issues because it's really easy for them to misstep and not realize some deal they're doing with a physician really violates STARK. And then document your training. When you do the self-disclosure protocol, one of the things they're going to ask you about is, did you have a compliance program and did you, follow it essentially? If you think you have a problem, again, you're usually better off entering into the self-disclosure protocol if that violation is confirmed. If you need additional resources concerning the STARK stuff, the government maintains a very helpful website that contains information about STARK, the list of DHS CPT codes. It contains information about the self-disclosure protocol and the like. There's a bunch of stuff online. The AMA has a very helpful guide that's available for anybody. The STARK Law Rules of the Road, you might check that out. AHLA, if you want to engage in the STARK self-disclosure protocol, you can download that protocol from the government's website, or the American Health Lawyers Association has a helpful guide. There's lots of stuff on the internet, but just make sure that you're careful about what you're looking at because STARK has changed over time. The initial parts of STARK came into effect in around 2000, but since then there's been STARK 1, STARK 2, STARK Phase 3. Make sure that you're looking at the appropriate version of STARK or information about STARK that is current. If you want additional information, there's stuff on our website. This program is recorded if you ever want to listen to it in the future or use it for your training purposes. We also provide health law basics, we also provide a health law update that sends out client alerts on these issues. For example, over the past couple of months, I sent out client alerts on physician contracts and STARK requirements for physician contracts. A couple of weeks ago, I sent out a checklist for STARK law requirements for physician leases. If you'd like to be added to that, to receive those emails, all you have to do is shoot me a quick email or go onto our website and you can sign up to receive those as they come out. We also have our Health Law Basics monthly webinar series. Our past webinars are available on our website. Our future webinars, just so you know, January is our month of compliance with fraud and abuse stuff. Next week, next Thursday, we'll be addressing the anti-kickback statute. Following that will be the following week, civil monetary penalties law. Following that, we'll be talking about responding to noncompliance, including self-reporting and repaying. If you'd like to participate in those webinars, just sign up and we'll make sure that you're added to the list. That is it. That is a relatively brief overview of STARK. I hope that it's helpful. Again, if you have questions, feel free to use that chat feature and send to me, or you can shoot me a quick email and I'll respond as quickly as I can. Thanks. We always appreciate your help. If you've got additional questions or suggestions for future webinars that we're doing this year, by all means, let us know so that we can take that into consideration as we schedule our webinars for 2015. I hope you all have a wonderful year.